All rise.
I'd like to mention two things before we start. First of all, at 11 o'clock, there will be an announcement which will be heard, I think, throughout the entire building that the 2-minute silence is to begin. And I'm told that we'll be also told when the 2 minutes are up. So I think what we'll do is when the announcement comes, we'll simply stand up and observe the silence together. The other thing is that I think it was on Monday, Lord Collins asked whether we could be given a schedule of the various rules which direct attention to the question of self-sufficiency on the one hand or exclude recourse to public funds on the other. It just simply we don't miss something out in looking through the entire collection. We don't need it today, but it would be very helpful if we could have it by the end of these proceedings.
Of course.
Thank you.
David, at some point we ought to nail the other anonymity things, really. I mean,
yes, we've had a note from Lord Panic about anonymity so far as his clients are concerned, but I did ask whether we could be told about anonymity for the others. So before we finish, we'd like to be reassured about that. And also, if I'm just one final thing, Ms. Councillor, there was a question of council being released so that they don't have to attend for AM2. As far as their lordships are concerned, we're not concerned to detain people any longer than they have to be, but I wanted to be reassured that there was no particular reason, so far as you were aware, why you should have to remain.
Well, Lord, I'm happy to deal with that on my behalf if I can. So far as anonymity is concerned, there is no concern about anonymity on behalf of my two clients. So far as needing to remain is concerned, with VS, there was an issue relating to disability discrimination that we attempted to run in the court below. For all sorts of reasons, it has not been possible to run that argument here, but how that argument is put may well have some relevance to the future conduct of VS. So we propose to remain for AM2.
Well, you won't have a speaking part in the...
But I don't think I can assert a speaking part in relation to AM2 unless something arises in the context of those submissions which requires me to add something, but I suspect that is unlikely.
Lord Panic,
our position is, without any discourtesy, I plan not to remain.
Yes.
My junior Mr. O'Brien, my instructing solicitor, Mr. Sim, will be here, just in case.
Very well, we're quite content with that. Thank you. Yes, Ms. Carsfield.
My Lords, I was taking the court yesterday to the relevant Immigration Directorate instructions and indeed an FCO general instruction of April 2001. If I could invite you to go back to that instruction very briefly at tab 5 of the IDI bundle, because I don't believe I referred your Lordships to one passage under paragraph 9.5 that I should have taken you to. It's page 34. And the heading you see just above the middle of the page is initial maintenance. An applicant may obtain financial assistance from a relative or friend in the UK to ensure adequate maintenance until the marriage. Such an arrangement is acceptable. However, there should be no dependency on such assistance after the marriage, as the rules require that the couple then maintain themselves. And then you have, of course, the separate section dealing with entry as a spouse, and I've taken you to the relevant passages there, particularly in paragraph 9.7. And if you just look at 9.7 again briefly, in the fourth paragraph, you have the reference to how, as it were, a longer-term arrangement that involves third-party assistance is not acceptable. Then you have a list as to factors which may need to be considered when assessing means of maintenance. And as in the IDIs that we looked at, the last bullet point refers to any support which will be forthcoming from others.
Yes.
Now, just picking up that point again, in our submission, and I have considered this overnight with my client, that plainly refers to the possibility of an exercise of discretion to allow third-party support in the short term, which is, of course, mentioned above in the substantive paragraph that says that for spouses, an arrangement of third-party maintenance would not satisfy the rules which require the couple to maintain themselves. And then you have the reference to nevertheless, it may be appropriate in certain circumstances, etc., for a limited period. So that's how those passages fit together in our submission, and the same would apply to the IDIs, where very similar language is used to deal with this point.
So you accept that support that's being talked about in that bullet point includes at least financial support as well as moral support, yes, or whatever other assistance might be offered?
Yes, the context would seem to indicate that, my lord. Yes.
Which is the fiancé rule?
I was just going to, yes, it's 290. I was just going to invite your lordships to that rule. It's at page 2937 of tab 8 of bundle 1. And here we say it is of some significance that subparagraph 4 of Rule 290 refers to a requirement that adequate maintenance and accommodation without recourse to public funds will be available for the applicant until the date of the marriage or civil partnership. And then at 5, and there will, after the marriage or civil partnership, be adequate accommodation, etc. And then at 6, the parties will be able, after the marriage or civil partnership, to maintain themselves, etc. So reflecting there, of course, the formulation that we have in Rule 2815 for spouses. So one can see a distinction in the fiancé rule between the formulation that applies for maintenance prior to the marriage and the formulation for what should happen after the marriage, which provides some further support for our general submission.
And little 4 matches the provision in relation to adoption, I think I'm right in saying it, which puts accommodation and maintenance together. I think
yes,
we looked at that yesterday.
Sense,
I've forgotten
yes.
the rule number, but it was
yes,
it was in the same form.
310.
310, thank you.
Yeah. Now, as to the status of the IDIs, we are grateful to my Lord Hope for drawing our attention to the case of ZT Kosovo, of which I hope your lordships now have a copy in front of you.
So it comes with a considerable health warning, I have to say, since nobody else agreed with me.
Yes, and I will be corrected extremely quickly if I'm wrong, but I understood from looking at the judgment that certainly although my lord dissented as to the end result, there wasn't dissent specifically on the particular role of the IDIs or whether the IDIs might be looked at in the judgments of the other members of the court.
Lord Newberger, I think, if I recall correctly, did raise an issue as to whether it was proper to look at them to construe the rules, did he not?
Well, my lord, I confess I hadn't spotted that reference, but my lord, we would say in any event referring to what your Lordship said at paragraph 38 to 39, that we can refer to the IDIs at any rate as, the way your Lordship put it at paragraph 38, an invaluable guide to the latest Home Office practice in the interpretation of the rules, setting...
Sorry, which letter is that? Oh yes, I got it, sorry, between C and D.
Yeah. Setting the rules, as it were, in their
Paragraph
proper
38.
practical context, paragraph 38. And that, of course, is the point that I understand my Lord hoped to be making at paragraph 39, further down, where it said, I should make it clear that my reasoning for referring to the APIs is not to use them as an aid to construction of the language, as I'm in agreement with all your Lordships as to what is meant by the words. It is to explain the purpose of the rule and the context in which it is designed to operate. That is a practical matter to which the APIs can act as a useful guide. So we rely on that really to support our submission that where the appellants say this was the regular practice, we can say, well, actually, not so fast. One needs to look at the practice as envisaged by the IDIs, and that is the context in which the rules are to be interpreted.
I understood this in part to be a response to a point that I think Mr. Gill made, but he can correct me later if I'm wrong, that he understood the practice to be the other way around
Exactly.
at that time. And you're saying, well, these AIs at least indicate that's not correct.
Precisely.
Well, I mean, all he was saying is that for 5 years, between Mr. Justice Collins's case, which is Amal Ali in 2000, and Mr. Justice Hodge in the tribunal in AA Bangladesh in 2005, one might have expected the practice to be in accordance with Mr. Justice Collins' unappealed ruling.
My Lord, there are...
So you're telling us that that was disregarded. Is that it?
No, my Lord.
Well, then how does it square with these rules, with these directions?
My Lord, there are 2 points that can fairly be made there. One is that in relation to Rule 2975, the child and parent rule, of course we know that that rule was amended after Mr. Justice Collins' judgment in Amal Ali to make clear, we would suggest, that which was implicit in the rule anyhow. But that rule was amended, we know.
Is there any material to show why it was amended? It was suggested in MW that it was amended to deal with Amal Ali, but that was merely a suggestion.
My Lord, beyond what we have on record as the presenting officer, the Home Office presenting officer, telling the tribunal as to the reasoning, we don't have any evidence, my Lord, no. So what the presenting officer said is what we have.
And where do we find that?
Sorry.
No, sorry. Where do we find what the presenting officer said? I know we've seen it, but I forgot.
That is, I'm sorry, it's one of the Bangladesh cases. It is, just one moment, my Lord.
54.
Yes, it's tab 54, or is it 56? Yes, it's tab 54.
In which
I'm very
volume?
grateful. In volume 6.
6.
Paragraph 29.
Yeah, that's right.
I'm afraid,
Oh, yes.
in response to my Lord Collins, I'm not able to assist beyond what is on record at paragraph 29.
Sorry, wait a minute. That's counsel for the ECO.
Yeah.
You said presenting officer.
I'm sorry, counsel for the ECO. I'm very sorry, my Lord. That was my mistake.
Well, no, but there was. I remember at some point somebody does talk about the presenting officer. So I can't remember where that.
It's yes.
It is the presenting officer.
Counsel, he had been instructed that, yes, that the immigration rules had been reconsidered once the Human Rights Act came into force third-party support had been relied on too frequently previously in this type of case, etc.
Do you have instructions on this point?
I'm afraid I don't, my lord. We have, can I put it this way, efforts have been made to ascertain the precise position at that point in time, and the best I can do is to refer your lordship to what is recorded here.
What is the period referred to in the sentence third-party support had been relied on too frequently previously in this type of case?
My lord, I'm afraid I'm not able to say exactly what the period...
Would it have covered the period of earlier instructions?
It presumably... well, I would have thought, my lord, that that may cover the whole period prior to this time when this matter is raised before the tribunal. So it may cover the period prior to Ahmed Ali, it may cover the period after Ahmed Ali and leading up to the time of this decision.
I mean, Ahmed Ali, October 99, ruled for what, just a year before the rules was changed? I think my lord said it was changed on the late September 00, is that right?
Yes, 24th September.
24th September 00.
Yeah.
Yeah.
And so the second point I was going to make, in fact, in relation to that, is that fair to note Rule 297 was amended, but also you have the sea change, as it were, of the Human Rights Act coming in after Ahmed Ali. We know that there was an audit of the rules and the introduction then of paragraph 2 in the rules that, of course, seeks to ensure convention compliance. And so it is fair to say that the Ahmed Ali ruling really was a pre-Human Rights Act ruling, which was very concerned to ensure compliance with the convention through the rules. And of course, that same imperative did not then apply after paragraph 2 had been introduced into the rules to ensure human rights compliance in that particular way. Now, that was certainly how Mr. Justice Hodge in the tribunal approached it in our AM case. If I can just remind you of that in the appendix in AM, it's page 92 of that appendix.
Sorry, so this is AM1?
This is AM1, my lord, yes.
Appendix?
Page 92.
Yeah.
And you may want to note first at page 96, paragraph 17, the tribunal refers there to the IDIs, and in particular Annex F, paragraph 5.1, which we, of course, have relied on also.
Sorry, paragraph 19.
17, I'm sorry, my lord. Page 96.
Yeah.
And you see Mr. Justice Hodge says there, this IDI is, of course, in no way binding on the tribunal, but it's an indication of the way in which paragraph 2815 has been applied by the Secretary of State and entry clearance officers. And then, if you would go to paragraph 24, page 98, one has the President of the Tribunal saying, in our view, Ahmed Ali should no longer be relied upon to support the proposition that third-party support is permitted if the underlying purpose of avoiding recourse to public funds is achieved. This case was decided prior to the implementation of the Human Rights Act, when domestic human rights jurisdiction was, in relative terms when compared with the situation today, in its infancy. The Human Rights Act now applies. And without reading through the rest of the paragraph, what one gets from that in our submission is the President there saying, in effect, well, Ahmed Ali really was prior to that sea change that came with
What is the human right of the child which is promoted by saying that it can't be supported in case of need by a third party, an uncle, that he should starve rather than that? I mean, what's the human right?
Well, my lord, we're not saying that there is a human rights imperative.
Well, what's this act got to do with it then?
I mean, as I understand it, what Mr. Justice Hodge is saying is, here comes the Human Rights Act. We can now amend the rules against the human rights because there's a separate human rights basis on which they can come in anyway.
Well, my lord, we would not read it as saying...
But that's what he's saying.
...change them against the Human Rights Act, but saying that you don't any longer have the concern that unless you construe the rules so as to make sure that there isn't a breach of human rights, you're going to have a breach, because we now know that by virtue of paragraph 2...
But this supports the view that you construe them more, so to speak, more harshly against the proposed reunification, because if it's necessary for Article 8 purposes, I'll get it through that separate route.
Well, it supports the view, we would respectfully say that the correct view, that one looks to construe the rules in the ordinary way to see what balance the Secretary of State has sought to strike, because, of course, some of the rules, or the effect of the rules, will frequently be to allow someone to enter the United Kingdom if they satisfy the conditions, where that would not be required by Article 8. So the rules are, in some respects, more generous than Article 8, but they also set certain conditions on entry. And so all the President is saying there in our solution is, well, you have to look at that balance between allowing entry and conditions on entry, requirements that have to be satisfied, that the Secretary of State has struck. Look at what the rules would mean on that basis, bearing in mind that you will always have human rights compliance through paragraph 2.
Is this point explained more fully in KP? You see in about two-thirds of the way down, he refers to KP. I'm not sure we've seen that, the Indian case.
Yeah, I didn't believe, my lord, that it was explained more fully in
Well, if it isn't, then we needn't look at it. But it's just, I just wondered whether he was expanding more to explain his reasoning.
May I, my lord, come back to that if need be, unless your lordship would like to look at it?
No, not particularly, but it's just in case there is something that be gleaned out of that.
We shall put
We don't know, I mean, this doesn't tell us why the rule was amended. I mean, it can hardly have been amended to narrow it in order that they should then have an Article 8 right. I mean, that can hardly be the purpose of whatever was done.
I don't understand the purpose was to deal with Article 8 in the particular amendment in 2975. I understand, as was recorded in the case we looked at a moment ago, that there were two motivations. One was child protection, not necessarily by virtue of Article 8, but just child protection generally. And secondly, that concern that we have seen about third-party support having been relied on too frequently and being difficult to verify, or words to that effect. The child protection obviously was a motivating factor there, this concern that there could be child protection issues if someone other than the parent actually maintains the child.
And where do we find the evidence of that?
That was the earlier case that we looked at, my lord, at...
That's 654.
654.
Para 29.
Yes.
But
that's
I mean,
right.
but I don't... are you sure that Lord Collins wasn't right yesterday in suggesting that actually what the child protection here is to make sure that, when it's said that this money is available through a third party, it really, really is. And because of the doubts about that, and if it doesn't come forward, the child won't be properly maintained. At least I think that's what my lord was suggesting, was the child protection aspect. I can't understand any other aspect of it.
My lord, certainly our understanding has been, and I'm not sure that this is disputed by anyone else on the other side, my understanding, or our understanding, has been that the child protection issue was not particularly about the money being available, but specifically about the danger of a third party extraneous to the family, in a sense having control over the child by providing the money. I believe that has been the common understanding as to what is involved here.
It's very far-fetched.
Absolutely incredible.
My Lord, we will obviously see if there's any way in which we can support that further. What I had understood was actually common ground between us, at any rate, as to the motivation there, or part of the motivation for the
strange it is, if this was the motivation, that there's no record of it apart from arguments in cases or something like that.
It's almost a suggestion of child trafficking.
Yes, exactly.
Yes.
That's exactly.
Yeah.
Well, that may be part of it, my Lord, yes, yes. Indeed.
Was the information, Freedom of Information Act inquiry, did this go to this?
I'm so sorry.
There wasn't some Freedom of
Yes,
Information Act?
I've just asked Mr. Hall to find the reference to the particular letter. There was a Freedom of Information Act request, and I think it was Mr. Nathan in the Court of Appeal who referred to that, and the child protection motivation came out of that.
Yes, but did it tell it what was meant by it?
I don't believe it went any further, but I'm just asking Mr. Hall to check that now. May I, my Lords, perhaps come back to that in the interests of saving time in a moment? So say, I don't believe it casts any further light on...
Have we finished with ZT? I can't remember. Did
Yes.
Lord Neuberger say anything?
It may be that what happened was that Lord Neuberger, in an initial draft, had pointed it out, and my paragraph 29 was a response to that, and he took out his criticism as a result of that.
Yes.
I think that may be the
my
position.
Lord.
Paragraph 39.
So on that basis, in answer to my Lord Brown's question, we are putting ZT to one side for the moment, until my learned friends come back and say why I'm all wrong in referring to it.
This is the FOI just.
Paragraph 29 doesn't really help. 54.
No, I agree.
My Lords, may I pick up just one point? Lord Roger referred yesterday to the changes in the definition of sponsor in the rules. I'm not sure if we took down your references correctly, but can I say overnight what our researchers tell us, which is basically that originally when the rules were laid, there was no definition of a sponsor in the rules. Although you did have the reference to a sponsor in Rule 317.
It is a little before 11 a.m. Today is Armistice Day. Please respect those who wish to observe a 2-minute silence in remembrance. I will announce when it is 11 o'clock and when it is 2 minutes past.
I think there's only about 30 seconds to go. Perhaps you should just pause there. I think you'll be interrupted in mid-sentence
Yes.
otherwise.
It is now 11 o'clock. It is now 11 o'clock. It is now 2 minutes past 11.
Thank you very much.
Yes, so no definition of sponsor initially, then you get the definition first inserted with effect from April 2003, that's HC 538, but at that time the definition only referred to those who wished to enter as spouses, fiancés, etc. Then you have a further amendment with effect from October 2004, where you now include the dependents, or rather the relative, whom a dependent may wish to join under 317. And that's, as I say, from October 2004. And then finally there was a further change with effect from November 05, which just included references to civil partners and same-sex partners in relation to the spouse rules and related rules.
Sorry, so the first one is I forget all these wretched numbers, 281.
The first one, yes, relates only to sponsors under 281 and other related rules.
The other related rules, does that include 297?
No, they don't.
Where does 297 come in?
297 doesn't, my lord. We don't actually have
it's not
a
included.
sponsor under Rule 297.
No,
It's excluded in the definition.
I see.
Yeah,
I
so
see.
that initial definition just referred to Rules 277
Yeah.
to 2950.
277 till?
To 2950.
Yes. And then the later one in October 04 was extending to 317 to 319.
That's right. Yeah.
And was that achieved by HC 582?
I understand that was Command Paper 6339.
And then
The final change came into effect November 05. That was HC 582. That included references to civil partners and same-sex partners,
Yes.
etc.
Well, that fits in with the footnotes at page 793.
Yes. My Lord, it was drawn to my attention that I perhaps agreed too readily with the suggestion that there was an absolute equivalence between part of Rule 290 and part of Rule 310. Mr. Hall has helpfully drawn to my attention that there is, in fact, some difference in wording. 3110.
I mean, my point, I think, is that it combines accommodation and maintenance in the
yes,
same
and that
heading.
was what I assented to, and that remains correct.
That's as far as I was making the comparison.
There are some other slight differences, but that
Yes,
point
exactly.
remains. Yeah.
Yeah, thank you.
Just picking up the point about what the amendment to Rule 297 was all about, I'm looking now at a copy of what was provided to Mr. Nathan in response to the Freedom of Information request. I'm very sorry, it's not apparently in the bundles, but I'm sure it can be provided to your lordships.
Monica, it's quoted by Lord Justice Laws, paragraph 46.
46. Yeah. It's referred to, I'm helpfully reminded, by Lord Justice Laws in the judgment below at paragraph 46.
Yes, yes.
And I'm afraid I don't think it assists us very much. The first paragraph cited by Lord Justice Laws really just says the rule change makes it clear the maintenance and accommodation must be undertaken by the parents or relative the child is joining. And then we have the reference to consistent with the intention and spirit, coming to join and live with the parent or relative.
So it's really the family unit coming together, I think, is the message. Is it to live with, join and live with the parents, not...
One can certainly read it that way, although that, of course, isn't inconsistent with a concern about child protection too. But at any rate, what seems clear is it's not about the finances.
I just want to be sure Lord Bryan has the reference.
I was looking at 46. I'm sorry, what are we getting from 46?
It's the very bottom of the page in italics, I think, is a quotation from the letter, beginning with the words taken literally.
Yeah.
And it runs over to the following page.
And this document is...
This is a response to Mr. Nathan made a request under the Freedom of Information Act. And
this is the
yeah.
IMI response, is it?
Yeah.
That's right, UK Border Agency. Yeah. Migration Strategic Directorate. And this was, as I understand it, handed up to the Court of Appeal in the course of that hearing, and then cited by Lord Justice Laws.
The proposition in the first sentence, which is at the very bottom of page 17, the last three lines in italics, is putting a rather wider interpretation of the relevant paragraph than we've been considering so far. I think this is suggesting that anybody can maintain and accommodate. We've been contemplating the use of third-party support or assistance.
Yes, well, of course.
I can understand a concern that it was as wide as that first sentence was going.
Yeah. Well, of course, on the appellant's understanding of third-party support, that could include anyone actually maintaining the child or maintaining the person in question.
Well, it's third-party support to the person who is the sponsor. Indeed.
Yes, it's maintained by the parents.
Parent.
Well, that's rather the issue, isn't
Yes.
it? Yeah, yeah.
Good.
But I think the concern was that the actual money could come literally from anyone.
Yes, but the point about that
yeah.
is, as my Lord points out, the reply suggests that the third party could give it directly to the child, and it didn't have to go through the parent at all.
And indeed, the parent might not have anything to do with the arrangement at all once they're in the
Well,
United Kingdom.
yeah,
That seems
I
to be the
understand
concern.
that was a concern, indeed, absolutely.
I mean,
And as
the
I
last-
understand the appellant's submission in these cases, there would be nothing to prevent that happening. I don't know whether Mr. Fordham would say that that was right, but certainly as we would understand some of the appellant's submissions at any rate, they would say generally in relation to these rules, you don't even have to have the sponsor as a conduit. You can simply have the money provided any which way from a third party, they would say.
But the vice that was identified here is really in the very last line of this. The child coming, relying on the settled state of the road, and then not living with them as a family. But I didn't think anybody was contending that that was permissible.
My Lord, certainly I don't believe Mr. Fordham, who dealt in particular with this rule, was contending that. No. But obviously there had been a concern that such a thing might happen under the old rule. So the new rule comes in, it deals with that, but it also, in our submission, ensures that you have financial support and looking after, in that sense, by the parent.
I wonder if you could just help me. I mean, back to the definition of sponsor and so on. As you pointed out, until whatever year it was, 2003, there was no definition. Is that right?
Yes, my Lord.
So if one looked at Rule 35, it just refers to a sponsor, a person seeking leave to enter, and so on. Now, who are these sponsors? I think we saw from some decision which we looked at yesterday that a very experienced member of the tribunal talked of charities and so on. And I suspect that reflects what the reality was, that there were people, charities and so on, who acted as sponsors. And from the point of view of the Department of Security, Social Security, whatever they're called at the time, of course the word sponsor was of no significance at all. What they were concerned with, under Section 78 of the Act we looked at, was a person who has either alone or jointly with a further person given an undertaking in writing in pursuance of immigration rules to be responsible for the maintenance and accommodation of the other person. Now, I'm at a loss to understand why the more the merrier wasn't the order of the day under that rule, because from the point of view of the Department of Social Security, then if you had two people promising to be ultimately liable, then so much the better. And I don't understand, what I'm really getting at the moment is, what was the policy which led them to, led the Home Office to change that rule and narrow the definition of sponsor?
Well, my Lord, one always had the concept, as we've seen, of the sponsor under Rule 317 being the person that someone seeks to join. Now, I understand that without a specific definition of sponsor, it may have been thought that actually under paragraph 35, the net could be cast more widely. But this really overlaps with what's going to be our submission on the broader question of joint sponsorship, which is that in our submission, it makes sense, particularly under Rule 317, where you are, we would say, looking at, in many cases, if not most, you're looking at long-term dependency in the United Kingdom, and it makes sense in that context to have one person that the entry clearance officer can look into and assess to try and form a sensible, informed view as to whether you really are going to get
Supposing
that
there's a charitable organisation
support.
dealing with people coming from Somalia, just to take an example, supposing it existed, that there was such an organisation and that it was saying, right, for this person and these people, then we are going to be responsible. We'll be responsible in that situation. What would be wrong with they would be perfectly forcible under the Social Security Act? They would be sponsors from the point of view of Rule 35. Now, what I don't understand at the moment is why that should have been removed and narrowed. That's what I'm getting at.
My Lord, I don't have specific instructions on that point, but what I can say, looking at the rules and what we have looked at, which is the concern reflected in the IDIs as well, that there should only be one sponsor, what I can suggest...
But why is that when the Act talks about either alone or jointly with other people?
Well, my Lord, we would say that there is a legitimate concern about the entry clearance officer being able adequately to check the situation. And that quite apart from the wording of 317, which perhaps we'll come on to when I do go to that submission, clearly the officer's job is going to be made a lot more complicated and more burdensome if he is going to have to check potentially maybe not just one more sponsor, but possibly more than that. And of course there can be concerns also in relation to a charity as to the long-term viability of that support. So what you have, we would say, as the inference from 317 certainly, is that the focus is on one person on whom the relative is dependent, who can be checked and whose intentions can be verified. But, my Lord, may I come back to that point, unless it would be convenient for me to simply move on to the joint sponsorship point now?
I think we should probably just move on.
Yeah, certainly. So, looking at that point then, which arises, of course, in the context of 317 specifically here, in our submission, if one looks at the wording, first of all, it does indicate a concern to focus on one person. You have the beginning of 317, that is to say, subparagraph 1, well, first of all, the introduction that refers to being the parent, grandparent, etc., or other dependent relative of a person present and settled in the UK. Then at subparagraph 1, related to a person. Subparagraph 2, joining or accompanying a person who is present and settled in the UK. And of course, subparagraph 3, referring to the dependency on the relative present and settled. And subparagraph 4, again referring to the sponsor. Now, of course, I'm aware that subparagraphs 1e and f refer to relatives in the plural, but as it were, the central provisions of the rule that apply to all the categories of relatives that can enter under this rule do focus on one person in the singular. And if you look at rules 6 and 6a and 35, they also appear to envisage one person. So in rule 6, you have a reference to the person in relation to whom an applicant is seeking leave to enter. Sponsor means the person, not a person. In Rule 6a, you have the reference to his sponsor and the sponsor.
But the Interpretation Act really gets over all these problems, doesn't it? I mean, you really can't put too much on the fact that it's in the singular there. It's perfectly capable of being read in the plural if the circumstances require it.
Yes, of course, leaving to one side any technical point about the Interpretation Act not applying to the rules as Odalola holds, I see that point, but of course one has to still look at what the overall, what the rule overall might nevertheless indicate is the intention. So taking my Lord Hope's point on board, one still has to see, well, is there something in the words used that nevertheless indicates that here we are focusing on one person. So just to complete that, you then have paragraph 35 on undertakings, also referring to, in the second paragraph, recovery from the person giving an undertaking, not a person.
Well, how does this square with section 78 6C of the Social Security Act of 1992, which refers to either alone or jointly with a further person given an undertaking in writing in pursuance of the immigration rules?
Well, my Lord, the fact that the Act envisages that possibility, and I accept that, doesn't of course necessarily indicate that the rules might not take the view, being the Secretary of State's policy, that there should be one person who is responsible for sponsorship. So, my Lord, that's what we say in relation to that, and
so the Department of Social Security have got to be content with one person rather than two. So that when they've not got any money, when they've had to fork out money, they could have had two people, but the Home Secretary says, no, tough, you can only have one.
My Lord, I can see that of course there may be cases where it would be useful to have two, but equally, if you look at, say, the facts of MI, where the two sponsors involve one who would in effect be providing no money, ANAB, and IAN, who would be providing pretty much all the money. So, of course, one may question in that sort of situation, what use would it be to have an undertaking from ANAB? So
no, but I mean, you can't just take it at that. I mean, you're saying that it's just, frankly, not possible even if they're both rich as Croesus.
My Lord, we're saying, looking at the rules, looking at the administrative burden of assessing more than one sponsor, and of course, in theory, one could have not just two, but 3 or 4, the inference is that that is not permitted. And that, of course, is consistent with the IDIs that I took the court to yesterday. Just for your reference, is the October 2004 IDI and July 2006. And there are, with respect, difficulties in applying the requirements of 317 to more than one sponsor. There's not only the question of how you sensibly say someone is dependent wholly or mainly on the two of them, if one, in fact, doesn't really contribute financially at all. That's one question mark. But you then have the issue as to accommodation, which in our submission does, on a fair reading of Sub-Rule 4, suggest that accommodation must be owned or occupied exclusively by both of them if you're going to have two sponsors. And that would create difficulties in many cases. MI is one such case. We've made the point that, as Immigration Judge Bolger found, the intention was that the appellants would live with ANAB, who apparently rents the accommodation in question. Now, of course, I
want to take you back. I'm just trying to follow what you're saying, but it doesn't seem to me too difficult to envisage a situation where sponsor A owns the accommodation, sponsor B is providing financial support as well. I mean, why couldn't you have that situation?
Where sponsor A owns the accommodation,
yes,
and sponsor B...
Sponsor B is assisting in the maintenance, providing support.
Well, my Lord, on a natural reading of the words, we would suggest, if you're going to simply read the word sponsor in the singular, as always including potentially the plural, then the natural reading does indicate that you have to have, first of all, existing dependency financially on both of them, on the relatives, present and settled then, and under 4, that you have accommodation which they both either own or occupy, because otherwise, in our submission, you really would be doing some considerable violence to the words of the rule. Now, I'm not saying these aren't these are problems that could not be overcome. But when we are looking to see what the intention overall might be, those sorts of difficulties with applying the requirements in our submission support the view that actually there is a concern to have one settled sponsor that the person seeks to join. Now, I was just going to acknowledge on the situation in MI's case, we of course seen the application form that refers to Ayan actually staying in the house of Anab, apparently. So I can't escape that, but it's not obvious how, if Anab then exclusively occupies pursuant to her tenancy, which we're told she has, it's not obvious how you then say that she and Ayan, even if Ayan is staying with her as her guest, we don't know quite on what basis, it's not obvious that then that amounts to exclusive occupation by both of them in the sense that we would say the rule requires. But, my lords, moving on to... Yeah. What change was that? Right.
To include 317, 319. It went from which is then reflected in the IDI.
Yeah. My lords, I'm reminded by Mr. Hall that when we had the rule change in the definition of sponsor that actually included the sponsor under 317, there was actually a change from a sponsor to using a person to the person.
So where's that?
You get that if you look at tab 56.
So changing the definition of what? Of the definition of sponsor?
It's definition of sponsor in Rule 6.
Yeah.
Yeah. Apparently we have the old definition in tab 57, bundle 6, at paragraph 4. That's the GG case we looked at briefly, I think, in the course of Lord Panic's submissions.
Yes. In paragraph 4, did you say?
Yes,
Paragraph 4.
It does say a person,
Yes,
yes.
that's right.
Actually, at the same time as you do this schedule, we're going to do all the rules, it would be enormously helpful, I'd find, if you possibly do the same thing for the evolution of the sponsor throughout the rules.
Of course.
How the position stood under which rule at any given time, with each amendment down to where we are.
And actually writing out how the rule read at any given
Exactly
time.
right,
Yeah.
yes, that would be very helpful indeed.
We can
Then we'd
certainly
actually
do that.
understand some of this.
Yeah. Yeah. And Mr. Hall also reminds me that you then have this change in the definition reflected in the October 04 IDI that makes this point about it not being acceptable to have more than one sponsor.
And the change was made at the same time as a change to Rule 317.
Yes.
Where's the IDI?
Yes.
Sorry, where's that?
Yes, it's command paper 6339. Yeah.
Sorry, which one was it you referred to just now?
It was October 04. Which tab is that?
October 04, yeah, command paper 6339, the new definition of sponsor.
In October 04 was the loose sheet, wasn't it?
The change in...
I'm sorry, the IDI.
Yes.
Sorry,
I'm
yes.
so sorry. Yes, that was handed up separately.
Yes.
And it's the penultimate page, isn't it? Or the last page.
It's the last page, absolutely. Paragraph 3.2, headed Further Guidance, which refers to Rule 317. In accordance with paragraph 6 of the rules, a sponsor means the person in relation to whom an applicant is seeking leave to enter, etc.
It's page 5.
Oh, yes,
It's
yes, sorry, yes.
very top line.
Yes.
And then the following paragraph Occasionally, an applicant may claim he is supported jointly by 2 or more relatives in the UK. This is not an acceptable arrangement. Such an applicant should be advised he will need to nominate one sponsor who he has been financially wholly or mainly dependent upon and who will be singularly responsible for his maintenance and accommodation in the United Kingdom.
I mean, I'm terribly sorry, but I just don't see how that works in the case of D&E. I mean, D&E explicitly contemplates that you actually have more than one relative who, I don't mean D&E, do I? I mean ENF.
Yes, I think you do mean D&E.
So you mean, my lord?
No, I mean
ENF.
ENF. ENF of 317.
Of 317, yeah.
Which, as we all know, says relatives. You're dependent financially on relatives. And here's an IDI apparently saying that's no good. We only have one sponsor who will be singularly responsible for the maintenance and accommodation.
Well,
So how does it work? I mean,
yeah. My lord, I can't claim, as I've said, that it makes up to a perfect whole, but doing the best one can. As I said, the key provisions seem to be little 1 as a whole, but then 2, 3, 4, and 4a. So that in a sense, what you have in 1e and f can be seen as subordinate to the key provisions at 2 and 3 and 4, and indeed 4a2, that apply to all of the categories of relative that you have listed in A to F. And they seem to settle it in favour of one person, although I entirely see your lordship's point that you do have that reference to more than one in E and F.
Well, it's very unfortunate, in fact, if that's your submission, because you would apparently qualify under E and F if you had two relatives who, sharing the burden between them, would meet the test, so that the individual is mainly dependent on them both. And then you come to look at the following things, and the case is ruled out because you have to choose between the two. And how do you choose between the two if they're
My lord,
providing
I'm
the burden
afraid,
equally?
yes, subparagraph 3 then actually says, yes, you have to be dependent on one person.
so actually, I mean, 3 automatically shuts out anybody who does qualify with respect to more than one relative under E and F.
But what it really means, yes, my lord, is that under E and F they have to effectively be dependent on one person, one relative, in order to then qualify under subparagraph 3.
Well, I mean, it's just rubbish.
Staying still with the case of MI, the second issue that arises there is, of course, the question of assuming you can have more than one sponsor. Do you have to name them all in the application form?
So we're on that assumption now.
We're on that assumption now. And in our submission, in order for the scheme to work, for the ECO to be able to apply these rules, there must be at least a reasonable indication in the application, on whatever form it is made, as to who is actually prepared to be a sponsor and to take on, of course, the potential responsibilities that arise, not least the potential giving of an undertaking, at least. Now, Lord Pannick said, well, it shouldn't matter what label is attached to a person. Well, that may be so in a sense, but what we're saying is that it should at least be made clear that someone is prepared to act in that capacity as a sponsor. Because if that isn't made clear, the entry clearance officer won't be able to make the relevant checks and to carry out his job. And that, of course, was the important point made by Lord Justice Laws at paragraph 93 in the judgment below. So it's not a pure technicality. It is a very real issue, as to how the ECO can do what he's supposed to do, how the scheme can be workable. And we do also refer here to paragraph 27 of the rules, mirrored in section 85.5 of the 2002
27,
Act.
did you say?
This is paragraph 27 of the rules. On page 2799, referring to how an application of entry clearance is to be decided in the light of the circumstances existing at the time of the decision. And you have that then mirrored in the appeal provisions, the 2002 Act, section 85.5b, 85.5b, which you have in the same bundle, tab 6, at page 50.
Sixth page.
Page 50, top left-hand corner, pagination. Little b, the adjudicator may consider only the circumstances appertaining at the time of the decision to refuse. So that applies in relation to this kind of decision. Now, again, we're not suggesting this is about labels, but it is about whether there was in fact someone who was prepared to act as sponsor at the time of the decision. It so happens that in this particular case, the case of MI, the tribunal actually found that it was always the intention only for ANAB to be the sponsor. So that can be a real issue. That reference is tribunal's decision at paragraph 31, page 40 of the MI core bundle. So paragraph 31 at the bottom of page 40, the tribunal says, I find that it is clear that Mrs. Ahmed, that's Anna, and the first appellant and those representing them always intended that Mrs. Ahmed would be the sole sponsor. And then a little bit further down in that paragraph, I find that Mrs. Ahmed was at all times intended to be the sponsor of the first appellant and that in any event joint sponsorship is not permitted. So you have that difficulty there, that it actually doesn't seem it was intended at the relevant time of the decision that there would be two sponsors, illustrating that difficulty.
So you're saying this is not just a mere technicality, it has a practical value?
Absolutely. It is about enabling the ECO to do his or her job and to consider, in particular, as Lord Justice Laws pointed out, whether to seek an undertaking from a sponsor. And of course, in order to do that, you do have to have a reasonable indication that someone is actually intending to be and prepared to be a sponsor.
You don't ask.
Well, my lord, it's fair and reasonable in our submission that there should be something to indicate to the ECO that there's an intention to be a sponsor. If there's then a lack of clarity, of course one would expect him to ask. But with respect, one wouldn't expect him to ask if there really isn't anything to make that clear.
I mean, is sponsor, when you see it on the form, does it sort of serve two purposes? One, to sort of indicate who the relative is, who you're coming in respect of, in respect of whom you're dependent in respect of. And also, that's a sort of shorthand, and also, it's also meant to indicate that that's the person who actually is going to give an undertaking if it's required.
Yeah, indeed.
Is that right?
Yes, and of course on our submission they have to be, yes, one and the same person, and there's no scope for...
Who may be asked to give it, maybe not
Yeah.
who has to give it, may be asked to give it an
Yeah.
undertaking. Is that right?
Yeah.
But I mean, if this goes to an ECO, right?
Yes.
I mean, if the ECO looks at this and, I mean, assume that you're wrong on the first point and that you can have joint sponsors. Obviously,
Yes.
if you can't, well, then he wouldn't be doing any such thing. But if you can, if he says, well, if any of these people had, the money's there provided that both of them are sponsors, and if only they'd had the wit to make that claim, they could have been, the application could have succeeded. I mean, presumably the ECO in those circumstances would suggest, well, perhaps you'd like to become a sponsor too, and then it's all right. Otherwise, we have to refuse. I mean, isn't that the way it would work?
Well, no doubt, if there's anything to suggest to the ECO, and accepting that you can have joint sponsorship, if there's something to suggest that someone is potentially intending to be a sponsor, if there's any doubt about it, no doubt he would ask. All we are suggesting is really at quite a low threshold requirement for an applicant, which is to somehow set out, reasonably spell out, that there really is an intention for whoever it is to be a sponsor. And the problem simply for these appellants is that the immigration judge found in terms that there wasn't an intention for both of them to act as sponsors until much later.
Well, only because they thought that it was simply not necessary. They thought it was just fine to have third-party support, because that's the basis on which this, as we see...
Well, my lord, I'm not sure it's right quite to go that far, because what we don't actually have, I don't think, the judge giving a particular reason as to why he thought that it hadn't been made clear, or it wasn't rather the intention for both of them to be sponsors. There may be a very real issue as to whether IAN would actually be prepared to be a sponsor in the full legal sense.
Well, the judge, I'm looking at Judge Bulger at page 49, paragraph 24. He regarded IAN as a co-sponsor. He didn't seem to have any problem in drawing that conclusion. I'm not sure, looking at page 53 at the ECO, whether he took the same view. The second paragraph under the word because on page 53 rather suggests he was looking for one sponsor only. I think that seems to be reasonably clear on a reading of that paragraph, but certainly when it went out to the immigration judge, he didn't have that problem, and that rather suggests that somebody with a reasonably open mind who reads the form can draw the appropriate conclusion.
Well, what I don't want to make too much of it, it so happens that it was looked at by the senior immigration judge in this case. He formed the view that we've seen at paragraph 31 on pages 40 to 41. That was his finding in this case. As I say, I don't want to make too much of it because it's very much about this case. But of course, if it were to be decided that joint sponsorship is permissible by your lordship's court, then all ECOs would approach it in that way.
Yes.
But one would still, in our submission, need applicants then to make it clear, one way or another, make it reasonably clear who it is that they're saying would be prepared to undertake that role.
Can I take you back to the wording of 317?
Yes.
Just so you can clear up something which is worrying me.
Yeah.
In line 1 of 3171, the words is related to a person must mean a person or persons. Do you accept that? Because of the structure of E and F in particular.
My lord, I don't think I would accept that that necessarily has to include person or persons, given our submission that overall the key paragraphs here focus on one person, we say, that the relative seeks to join.
Well, how is that square with E and F?
My Lord, it doesn't.
No, well, in that case, how can you not say that in one, a person means anything other than a person or persons?
Well, E and F, of course, have the primary requirement, as it were, of being a parent or grandparent. If you will look at E, for example, parent or grandparent under the age of 65, living alone outside the UK in the most exceptional, compassionate circumstances. So you have the focus on being a parent or grandparent related in the requisite way. One can read the reference to financial dependence there as separate from the requirement in that subparagraph of being related to one person.
Yes, but if one stood alone, if paragraph 1 stood alone, you'd be in great difficulties in saying that a person meant a person and not a person or persons.
My Lord, I accept certainly we need to read it with, of course, the remainder of the rule and the other references there.
Yes, but if it did mean a person or persons, then there would be no reason not to read the relative in 3 as relative or relatives.
My Lord, it could be done, and then you have to look at the other indications in the other rules that I've referred to see whether that's sensible, and the administrative difficulties I've mentioned.
Thank you.
Just completing on MI, we have the reference there, of course, to the Court of Appeal, saying that the finding that the money would be sufficient from both of the parties, ANAB and AN, couldn't stand. Your Lordships will recall, I think Lord Panic took you to what Lord Justice Carnworth had said about that in the Court of Appeal. And he suggested that that was something, if he was otherwise right, that would need to be reinvestigated in the tribunal.
Yes, if he wins, it'll have to be remitted for redetermination.
Yeah.
Is that all you're saying?
Well, that's what Lord Panic said. What we would say is simply this. The immigration judge actually made a clear finding. He looked at sufficiency of funding. He said it was enough, so he really did deal with that point. Just for your reference, that's page 49, paragraph 28. The Court of Appeal then took the view that that simply couldn't stand. It made no sense because effectively it meant that the IAN would have to give up a huge part, I think 2/3 of her income. Lord Justice Laws dealt with that slightly differently from Lord Justice Carnworth at paragraph 97 of the judgment below. All we say is really, given that you have a finding by the immigration judge on this, which the Court of Appeal has said in pretty clear terms can't stand, that really ought actually to be the end of the matter on that basis.
I'm trying to follow what is being said on page 49, just to keep pace with you. Are you saying that the immigration judge accepted that IAN's commitment and contribution would be enough to meet the relevant test?
Yes. Yes, he dealt with that. He said it would be enough.
Yes.
Court of Appeal then said that is not a sustainable finding. And Lord Justice Carnworth certainly indicated that if the appellants were otherwise right, that might have to go back to the tribunal to be looked at. All we say is there really any basis for that, given that you have a finding, dealt with it fully, Court of Appeal says no, it isn't a sustainable finding.
So even though the Court of Appeal thinks it's necessary to remit it, we should conclude that it isn't necessary.
My Lord, Lord Justice Carnworth suggested that. Lord Justice Laws at paragraph 97 put it rather...
Well, he put it differently, but I mean, he does say it cannot stand absent some reasoning which shows how it may be supported. He doesn't say it's inconceivable there could ever be any reasoning to support it. That's why you've got to remit it.
My Lord, I can't improve on my submission. Paragraph 3173. An issue was raised yesterday as to whether we might also have had an argument that subparagraph 3 wasn't satisfied in this case. It was not a point that was raised in the Court of Appeal. No. There were many other points, as we know. We don't seek to introduce it now. I just wanted to make it clear that, of course, we don't accept, and we shouldn't thereby be taken to accept, that you could have a mere conduit who provides money to the relevant relative within the meaning of subparagraph 3. In other words, our submission, of course, is that financial dependency under subparagraph 3 involves actual dependency on the sponsor and does not involve the sponsor getting the money from someone else. So that's just consistent with all our other...
So you're maintaining your position in VS?
Yes, precisely.
I mean, you say that even if you lose on Roman 4A, you still win, as indeed Lord Justice Carnwath said you won on 317.3.
Yes, my lord.
Is that right? I mean,
that is right. Yeah.
And Lord Justice Laws doesn't seem to have expressed a view on that.
No, I think that's right, my lord. I'm very conscious that I have well exceeded my over-optimistic estimate of how long I would be yesterday.
Yes, I agree, yes. I agree. Yeah, I agree.
I'm sorry, on you go. If you finish your...
I'm sorry, it's my fault.
Submission. No, it's my fault entirely. I'm just discussing with colleagues where we go from here. But do you have any more submissions to make?
My lord, as I say, I'm very conscious that I've gone over my time estimate. Incredibly briefly, on the other, as it were, main points on the interpretation issue. As to the correct approach on interpretation, generally you have that in paragraphs 43 to 45 of our printed case.
Now, which printed case is that? The main one?
This is in AM1.
Yeah.
I don't need to add to that. It's
paragraphs
43 to 45. It's the decision of the House of Lords in Odolola, in particular the speech of Lord Hoffman at paragraph 4. I don't think that's actually disputed. On the second point, that the rules don't have to guarantee convention compliance in every case, we refer to paragraphs 46 to 55 of that printed case. And in particular, of course, we say accepting that the rules may possibly lead to a breach of Article 8, it doesn't follow that they have to be interpreted so as to permit third-party maintenance in every case. That's really the gravamen of that submission.
Yeah.
And as to the notion that there is, even absent the Human Rights Convention, some overarching policy that should always tilt the interpretation in favour of promoting family life, we do say that what you have here is actually, in these rules, fairly clearly two objectives. One is certainly enabling the kind of family union that the rules envisage, but also, of course, safeguarding the public purse. And if one looks back at the case of M&A, that Mr. Gill in particular relied on, and I won't invite you to go back to it, but it's paragraph 21 of Lord Justice Dyson's judgment, and you have M&A at volume 5, tab 42. One sees that Lord Justice Dyson actually identified the twin objectives of the rule, in that case Rule 297, as the promotion of family life without recourse to public funds. So you don't have, as I say, that overarching purpose of promoting family life that tilts the balance inevitably one way or another. As for the submission that if we're right as to what the rules mean, then they must be ultra vires, I refer to paragraph 67 to 69 of our printed case. Now, insofar as Mr. Fordham was saying, well, if the rules precluding third-party support can result in something that is incompatible with Article 8, then they're ultra vires. If that's his submission, then we respectfully say he's wrong for the reasons given in paragraph 69. The immigration rules go further than what is required by Article 8, in many instances permitting family union where that would not be required by Article 8. And so a refusal of entry to someone who, say, fails because there isn't adequate maintenance or accommodation will by no means necessarily involve a breach of Article 8. And the case of SA and AW is actually a good example of that, because there the tribunal found that family life could be enjoyed abroad, as it happens in Somalia in that case. See the appendix pages 84 to 85, paragraphs 45 to 49. So on the facts of that case, we would suggest one couldn't say that prohibiting third-party support would lead to any breach of Article 8. In any event, as we've said in paragraphs 82 to 85 of our case, no freestanding Article 8 claim was actually pursued in the Court of Appeal in SA and AW. Although it's fair to say I wasn't entirely clear whether that was actually being pursued before you. And my lords, finally, so far as the Article 8 claim of AM is concerned, we deal with that in paragraphs 80 to 81 of our case. We say the tribunal very carefully assessed the position in accordance with Huang and made no error of law in so doing. My lords, for all those reasons, we invite you to dismiss the appeals.
Thank you very much indeed. Well, we'd like to adjourn for a while just to discuss the topics on which we would invite a reply. We'll be as quick as we can, but if Council will be kind enough just to wait within reasonable bounds so that we can resume as soon as we're ready. Thank you very much.
Yes, of course. That's assuming we'll record.
I'm sorry?
That's assuming we'll record the conversation.
Oh, I think we will, because he said...
I did do some supplementary.
All rise.
It may assist Council in deciding on the topics on which they feel they need to reply if we were to indicate that we do not need to reply on two matters. The first is on the point as to whether, under all three rules as presently written, third-party support is permissible. We don't need to reply on that point. And the second is on joint sponsorship in general. The issue as to whether joint sponsorship in general is permissible, and in particular, in MI's case, despite the fact that the daughter was not named on the form, it was appropriate for her support to be taken into account. We don't need to reply on that point. Mr. Gill, can I mention that the Lordships would appreciate guidance on your position in regard to Rule 317(3), and Mr. Fordham, 2 points for you. First of all, the anonymity issue, so far as SA and AW are concerned, because we've cleared up the others, but we would like to know whether anonymity needs to be preserved in their cases. And also, so far as Article 8 is concerned, we suggest that you could build any points you wish to make on Article 8 into the argument that you're going to be presenting anyway on AM2's case, rather than take a separate issue. So you can take that all in one if you find it more convenient.
My Lords, the submissions will then be somewhat more truncated than
Yes.
would otherwise have been the case. Can I therefore simply say we maintain the position that we did in opening, and I don't repeat it. However, before turning to the issue in relation to 3173, I just want to draw one point to your Lordship's attention in relation to the other side's concerns about investigation and matters of that sort, and requiring undertakings, etc. My Lords, we say that under all of these rules, third-party support is permissible, and the question of whether it can be permitted without regard to undertakings is really irrelevant. So far as the case of Ali Ahmed is concerned, which my learned friend Ms. Castfrisk put before you, it would be, if I can simply say, that in paragraphs 42 and 56 of that case, the Court of Appeal itself recognized
Sorry, paragraphs 42 to what?
42 and 56 of the case of Ali Ahmed. There was the Social Security case that Ms. Castfrisk put in front of you.
Sorry, you'll have to give the tab number so we're quite sure we will.
It didn't have a tab number.
Oh, it's a separate piece, is it?
It was a
Yes.
separate piece. it provides support for some of the comments that have been falling from the court.
Yes.
This is not something we've had yet. Oh, yes, it is.
Yes, it is.
Yes.
And I'm sorry, I didn't write the paragraph numbers. 40.
42 and 56.
Yes.
What they say there is that the Secretary of State accepts that under 317 doesn't require an undertaking. Even Rule 35 doesn't require it. An officer can be satisfied with what the Secretary of State needs to be satisfied for the purpose of Rule 317 without the extraction of an undertaking. And at 56, Lord Justice May said the relevant rule is 35. It's not 317, since that rule doesn't speak of an undertaking. And it is accepted that the conditions of Rule 317 can be accepted without the need for an undertaking. And again, at 59, Council for the Secretary of State so accepted. So at best, this point that you've had this point that you've had in relation to Rule 35 is simply a point to deal with, to say that there are supporting mechanisms in place.
Well, you don't really need to develop that because that's all part of the argument on the interpretation of the rules, isn't it?
That's right.
It's a separate issue.
But I simply wanted to draw to your attention that it is not simply the maintenance undertaking itself that the Secretary of State has at his disposal if he's got concerns about the adequacy of an arrangement.
That's
what he can
straightforward.
do under Section 159(9)(b) of the 99 Act is also impose a restriction that there be no recourse to public funds. You've been shown Section 115(9)(c), which says he can require a maintenance undertaking, and if there is a maintenance undertaking, the person is subject to immigration control, therefore excluded from benefits. He can do more than that. If he wanted to, he could impose, even in a case where there's indefinite leave to enter or remain, he could impose a restriction saying there should be no recourse to public funds. So he's protected in that sort of way. There are a number of protective mechanisms, therefore, that he can put into place to ensure that such risks as he thinks that there might be, assuming 317 is not satisfied, are met.
Well, I think we can leave the point there.
The issue then really in relation to 3173 can be dealt with in this way. Once it is accepted by the Secretary of State as it is, that money from a third party by way of gifts, loans, and such like are acceptable money, gift and loans to the sponsoring relative are acceptable. Once that is accepted, there is no reason for construing Rule 3173 in any other way than to accept that money coming from a third party, so long as it goes into the hands of the sponsoring relative, is money that the sponsoring relative can use to support.
Sorry, could you just repeat that?
Yeah.
Any other way than so long as the money goes where?
Into the hands of the sponsoring relative, I think.
Once it goes, so long as it goes into the hands of the sponsoring relative, that money can be used to discharge the obligation to maintain the intending immigrant.
The what?
The arriving immigrant, the applicant.
I thought we were, so are we now looking at Roman 3?
Yes, yes. The point is this. Let me put that again. Once it's accepted that monies by way of gifts and loans and such like are acceptable
For 3174A purposes.
Well, the submission was in relation to how dependency is to be discharged. The submission cut across the whole of the rules. And what the Secretary of State is saying is, as long as the sponsoring relative in this country has money in their hands, or it can be obtained through a legally enforceable mechanism, so long as that's satisfied, It doesn't really matter where the money comes from. It can be by way of gifts, it can be by way of loans, it can be by way of pretty well anything, as long as it gets into the hands of the sponsoring relative.
Just in the ordinary meaning of words, if I'm in Somalia and I'm receiving money from my son in England, and that's my only source of means at all, am I not dependent on my son, irrespective of where he gets the money from?
Absolutely. And that is what the Secretary of State's opening concessions make absolutely clear. It doesn't matter where that money is coming from. It's coming into the hands of the sponsoring relative. It's coming by way of gifts, loans from third parties. As long as it's in the hands of the sponsoring relative, the question really is, what can the sponsoring relative do with it? Well, what he does with it is up to him. What he does is he uses it to discharge his obligation to, he maintains his, in VS's case, his father with it.
Now, I'm making a slightly different point. Just simply, if I get money from my son, and that's the only place I can get it from, am I not dependent on my son?
Indeed, indeed. And that's the long and the short of it. And the Secretary of State's concessions as to what form of funds from third parties can be acceptable for the purposes of the rules. This was the overarching submission right at the start of Ms. Carsterisk's comments. If that submission is right, that's how the Secretary of State understands the position. If that's right, third party gives funds to the sponsoring relative in the United Kingdom. The relative abroad is dependent upon that son. The son provides that money to
in the situation you're envisaging, it's very likely that the son has taken the initiative of striking up the relationship with a third party on behalf of his relative abroad. Is that not likely? The whole point is that he's seeking to provide support for the relative abroad. And he realizes he hasn't enough money of his own, but can strike up a relationship with a third party to achieve it. But the vital link, you say, is that it's through the relative.
Through the relative. Country. That's right.
I mean, here Mr. Aruna was, in fact, the son's friend.
Yes.
So you have that to be said on your... I mean, if it had been the father's friend... I'm sorry, are we talking father here, or is it...
Father.
It is
father, yes. I mean, if it had been father's friend...
Yes.
You might have been in more difficulty.
But that's not the situation here, my lord. If I can go to the bundle in the core bundle in VS.
Yeah.
In VS's case. And go straight to the relevant document, which is the immigration judge's decision, appendix, page 59. You'll see at the bottom.
Sorry.
The right turn.
Appendix in VS, page 59, paragraph 71 at the bottom.
So this is the AIT?
This is the first instance fact finder, immigration judge.
Oh.
And this is the critical finding. The AIT's subsequent views on it with respect don't particularly matter, because this is the finding that one has to go back to.
So VS's case, and it's page 59, paragraph
71.
Yeah.
See, it says there, it is said that because of the provision of funds depends upon the friendship between Mr. Arunan and the son, and in reality, the provision is dependent upon the relationship between the sponsor and the appellant.
Yes.
That may be correct insofar as it goes. It may well be the reason Mr. Arunan provides support to the appellant is because of his friendship with the son. It doesn't rule that out at all.
No.
Although the tenor of the evidence of the family was that he was happy to provide the support because the overall family connection, he knew the family, had some respect for the family and so on. Then this, yes. whatever the reason for the provision of support, the fact remains that the support comes from Mr. Arunan and not the sponsor. Thus, I regret the 3173 is not satisfied. So he regrets, he reaches his conclusion on the point of principle that because third-party support in principle is not prohibited, is prohibited, this arrangement can't work. That's why he says, whatever the reason for the provision of the support, fact is it comes from somebody else, and therefore I can't allow this to succeed under 3173. But that is not the right approach. If the right approach is that third-party support is capable of being permitted under the rules, then what he's got to do is not simply say whatever the reason for the support, he's got to ask what is the reason for the support, reach a conclusion on it, and it is clear that what he would have done had he addressed that question is to say, go back to his finding in paragraph 71, that yes, it does appear to be that it's this relationship between the son and Mr. Aruna.
The first sentences indicate that he hadn't been diverted by the point he ends up with. He would have made a finding in your favour on that very point.
Absolutely.
I mean,
Absolutely.
you could have a situation where the father, as Lord Collins says, the father simply receives the money from the son. He never inquires, or the son never tells him that he's actually getting it all from Mr. Aruna. Outwardly and visibly, he's being supported by the son. It may be when it comes before a tribunal, lo and behold, the son has to confess that actually it's his friend who's been supplying all this money all this time, and he hasn't been doing. But as Lord Collins said, he would think, the father would think, certainly, that he was dependent on the son, and in reality, he would be.
Absolutely, that's right. And the interpretation for which we contend in relation to 3173 is in fact of a piece with the acceptance throughout the authorities, such as in M&A, on which I've laid stress, that once you recognise, and as the Secretary of State has also recognised, that the overriding, certainly the IDIs do, I'm not sure about the submissions, that the overriding purpose is that there is an overarching purpose for these Part 8 rules, these family member rules. You try to bring together family members so long as there is no additional recourse to public funds. Once you recognise that that is the overarching purpose, contrary to what, with respect, Lord Justice Laws said, then it makes no sense at all to say that for 3173 purposes, we're actually going to completely rule out support from a third party, even though...
Mr. Gill, is that really right? Because, I mean, how can you say that the real purpose of 3 is to protect the public purse? I mean, that is a further precondition. You're only allowed to come as a dependent relative under this rule, and we went through all this to occasion. I mean, if he was, if actually father had been maintaining himself happily at home, then I'm terribly sorry. Even if he reaches an age, he loses his job, he cannot come here because he hasn't hitherto been financially dependent on the relative.
I think I have to accept that, yes. But
so anyway, but there it is.
But you have my central, the point that I've made in relation to the interpretation of the rules in this sort of situation. That is the only point I think I wanted to make in relation to 3173 and BS. I don't think in those circumstances that I actually want to address you on the rest of the detail that I would otherwise have put before you.
No, I don't think their lordships are looking for any further assistance from you, Mr. Gill. Thank you very much.
Thank you.
Now, Mr. Fordham, do you want to say anything at this stage?
May I make 3 very brief points?
Yes.
The first, as to anonymity, there is no difficulty at all in relation to SA, who is the wife, but there is a concern about the child, AW.
Yeah.
And we would invite the court to consider whether to maintain the anonymity in relation to the child.
Sorry, why is there a reason for that?
Simply for that reason, that it is a minor. I'm not putting forward any further justification, but that's the concern I've been instructed to raise with you.
Simply because the child is a child?
Yes, that's right. That's. I don't advance a submission. I simply remind the court of the factual position. I hope that's a proper way to deal with it.
Okay.
The second point, in relation to the IDIs and the disregard of Mr. Justice Collins' judgment, because it may be that the court will wish to comment on this, and there are simply two things I would like to show you on that.
Yes.
The first is that the tribunal had reinforced the settled meaning of the rule. For example, in a case called Panache, which is Volume 6, Tab 66, Authorities, Volume 6, Tab 66. This is February 2001. I simply mentioned one paragraph, if I may. It's paragraph 14 in this determination. It's Mr. Ockleton, and he says at 14, the adjudicator appears to have considered that third-party support was acceptable only for a very limited period of time. That proposition cannot stand in the light of Amal Ali. So third-party support is relevant, and indeed long-term third-party support. Now that's the 23rd of February. The Foreign Office's next document, which you saw at page 35, was...
I'm terribly sorry.
It's the 23rd of February 2001.
What have we got from paragraph 14?
It's the tribunal explaining that third-party support is permissible, and permissible even though it's long-term, because that's been decided by Amal Ali.
Quite, but what's that got to do with the IDI?
Well, the IDI then comes in April 2001. Sorry, it's the Foreign Office document.
So this is
and
a decision of what? This is a decision of February tribunal decision?
Yes.
23rd of February 2001.
Yeah.
And I think I've got my chronology right when I say that page 35 of the IDI bundle was the Foreign Office promulgating an instruction, and you've seen the statutory provision.
Sorry, you're going too fast.
It's tab 5, you say.
I don't have the tabs, but it's page 35.
Yes, it is tab
2001.
Who promulgates these?
This is the Foreign and Commonwealth Office, as I understand it from the index. FCO General Instructions. And I simply wanted my lords to see in chronological context that it is then said by the Foreign and Commonwealth Office in their instruction that decision makers have a statutory duty to apply, provided that it is consistent with the rules, that such an arrangement would not satisfy the rules. Well, that's simply wrong.
Where are we looking in tab
It's
5?
page 35, my lord. It's 9.7, and Ms. Carsfrisk showed you.
Yes.
Paragraph 4. For spouses, such an arrangement would not satisfy the rules.
Yes.
Well, we've got
Halfway
the
through
High
the paragraph.
Court, and we've got the tribunal reinforcing it.
So it's back to the limited period of time, which...
Well, that in fact was the very point that Panache had dealt with.
Indeed, yes.
That's the first aspect of this. I'm not wanting to go back over old ground, simply so that my lords have the additional...
So what you're
features.
saying is that within 6 weeks of a tribunal decision saying, pursuant to Amal Ali, it's okay,
Yeah.
here's a rule, here is an IDI published saying the contrary.
Yes, and not as a matter of policy, which would be impermissible in itself, but as a matter of what the rules mean. With respect, we would...
How do we know this is the interpretation of the rule as opposed to...
Because it says the rules do not allow.
Would not satisfy the rules.
Would not satisfy the rules.
Panache was a 281 case.
Yes, it was.
Yeah.
Right?
It was a 281 case.
281 is Ismail's case, so it's precisely on the point.
It's exactly on point. This is why I wanted to take a little time to make sure that the court was fully aware of how lamentable this episode truly is. The second aspect, which I know you already know about, because it was the Pizza Uncle case at tab 62, which on the 31st of May 2002 had again returned to the point in the context of a spouse. Now, I don't go back, but you saw paragraph 12 and you saw paragraph 16. It's settled meaning of the rules authoritatively determined by the judicial arm of the state. What I didn't show you, but would now like to show you, is the very last subparagraph of this determination. My lords, I hope have, on the last page at 17b, having said in the previous paragraph that Mr. Justice Collins was a clear statement of the law that had been ignored, with the consequences for that family and its unity. My lords, I hope you have 17b, that a copy of this determination is sent to the Chief Adjudicator, the head of the Visa and Migration Department at the FCO, the Under Secretary of State at the IND of the Home Office. And it was in April 2004.
Yeah. So, sorry, just to pick this up, I mean, it's really giving effect to the complaint, which is in the last paragraph of paragraph 16. Is
Exactly.
that despite the interpretation?
Clear
So
statement of the law being flouted, being disregarded. And again, just to complete the chronology, you saw the IDI in the IDI bundle at page 21.
Page one.
Page 21.
So we're in tab
This is 3.
3, and it's April 2004 now.
This is April 2004. Paragraph 5.1. This is not acceptable as the rules require the couple to be able to support themselves and any dependents from their own resources. Well, this should not have happened and should never happen again. That's the second of the 3 points. The third of the 3 points, my lords, is in relation to the Freedom of Information Act request and the purpose, the child protection purpose. And I don't want to draw back over it, but simply to mention that you have somewhere among the papers a 2-page additional submission.
Yes.
And it's Mr. Gill's document, not mine, but it may be of assistance in relation to this point for you at least to know.
Could you just a moment to find it? Which case is it headed in?
It's in AM Somalia. It's got 2 firms of solicitors, bottom left-hand side, Sheikh & Co and Kingston and Richmond. And it's the thinnest of the blue-covered documents that you have.
Is it the witness statement?
It's not stapled. Yes, it's bound like that.
Witness statement to...
No, appellant's additional submission.
You're right, yes, I'm sure I've got it somewhere.
If it assists, I'm sure we can.
Yes, I've got it.
I'm very
It's the
grateful.
same thing. Yeah.
And I hope it is forgivable for me at least to make you aware that you've got that, and you've got at paragraphs 5 and 6 in particular in those submissions which we certainly would respectfully adopt. A description which you may find helpful in the context of that purpose and the passage quoted by Lord Justice Laws. You may recall I had dealt with this in my printed case in AM number 2 at paragraph 12. But of course I don't ask you to go back to that document. I perhaps can just remind you of it. My lords, those were the only points that we thought it might be of some assistance for us to raise with the court.
Thank you very much indeed. Yes, Lord
Lords,
Canning.
3 very short points. The first of them is we respectfully agree with Mr. Fordham that the instructions to immigration officers, which the court has seen, raise 2 points of very considerable general constitutional concern. The first of them is that it is plain that the Secretary of State is issuing instructions which are simply inconsistent with the immigration rules as interpreted by the High Court and the Tribunal. And that is contrary to paragraph 1, subparagraph 3 of Schedule 2. We've provided now copies, I don't know whether they've reached your Lordships, of paragraph 1 of Schedule 2 to the Immigration Act. It's a single
where have we got that?
I hope it's been put on
I see. Is it
desk.
one single piece of paper?
One piece of paper headed Immigration Act 1971,
Oh, yes, I've got it.
amongst all the
Is it
other
a single piece of
many
paper?
pieces of paper.
And this is Schedule
Schedule 2.
2, and it's
Paragraph 1, subparagraph 3. In the exercise of their functions under the Act, immigration officers shall act in accordance with such instructions, brackets, not inconsistent with the immigration rules. And it is simply unacceptable, in my respectful submission, for the Secretary of State to be issuing instructions which... So, my Lord Collins, I think, doesn't have a copy. I'll hand up another one. My Lord does have a copy, thank you. It's simply unacceptable for the Secretary of State to be issuing instructions which are inconsistent with the rules as interpreted by the judicial authorities. If the Secretary of State doesn't like the interpretation, he's at liberty to appeal. He's at liberty, subject to the consent of Parliament, subject to Article 8, to amend the rules from time to time. The second matter I suggest of some constitutional concern is this. It is also, I submit, quite unacceptable that, as stated by my friend Ms. Cars-Frisk, the Home Office does not retain, it seems, an archive of the instructions that they have issued from time to time. My friend said that she's done her best, those behind her have done their best to identify the relevant instructions. They must, in my submission, keep an archive of documents that have a statutory role, see paragraph 1, subparagraph 3, and which the Home Office is relying upon, as my Lord Hope said they can rely upon them, for the purpose of demonstrating what the practice is from time to time. I would respectfully ask your Lordships in the judgments, if the Court thinks it appropriate, to say it is a breach of a fundamental constitutional principle for government to adopt and apply instruments of which it apparently doesn't keep copies. It cannot be for the appellants to try to
Well,
identify.
there are probably copies buried somewhere, but they're not quite sure where.
That's not what Miss Cars-Frisk said. Her instructions, as I understood them to be conveyed to the Court, is that they simply don't exist. The second matter that I wanted to respond on, second matter of 3, is that my friend drew attention to the observation by the senior immigration judge in the cases that I appear in at page 40 and 41, paragraph 31, that IAN was not intended to be a sponsor. There was a point about a factual finding in relation to her. The passage is in our core volume, appendix page 40 and 41, paragraph 31. The statement by the senior immigration judge that IAN was not intended to be a sponsor. It's true in that passage the senior immigration judge also takes the view that joint sponsorship is not permitted, and that may have affected his judgment on this point. The response I wanted to emphasise to the Court, if I may, is that the immigration judge who heard the facts, of course the senior immigration judge did not hear any evidence, the immigration judge who heard the evidence said at page 49 on paragraph 24 that he was entirely satisfied on the evidence of IAN as co-sponsor, that she is entirely sincere and genuine in her wish to assist the appellant from her own resources. So he regarded her as a co-sponsor, having heard from her. She was, there's no dispute, at all times willing to provide the financial support, and the form which the court saw yesterday, specifically says at the top of page 64, if it matters, in the first line, paragraph 6.1, the answer given is but third party sponsor. So it can't be suggested.
6.1.
1 at the top of page 64.
And that's
a third party sponsor.
That's 6.7, isn't it?
I'm sorry, Lord?
I think it's 6.7.
Your Lordship's correct,
Yes.
6.7. So if it matters how people are describing themselves, I draw attention to that. But the reality, of course, is that the form made clear that finance was going to be provided by IAN. The ECO could, and I say he should, if it mattered, have looked at the form. He should have said to himself, properly directing himself, there can be co-sponsors. This is plainly a case where I should ask IAN if she wishes to be a sponsor, if that matters. The final matter, my lords, is that my friend Miss Cars-Friss referred to the Court of Appeal finding that the immigration judge erred in finding that there was sufficient money here. And your lordships made the point to my friend, the reason why remission is appropriate, because Lord Justice Laws said at paragraph 97 that the finding on the facts that there was sufficient maintenance cannot stand absent some reasoning which shows how it may be supported. That was paragraph 97. That's why Lord Justice Carnworth, paragraphs 111 and 114, thought there should be remission. And remission, I say, is the appropriate solution here.
Yeah. Just I mean, it's in that form which we were looking at, 6.12 and 6.13, I take it, are actually there. She's referring to IAN as being, and the answer, has your sponsor been in this employment?
Well, indeed, that's referring to IAN.
Yes, it must be.
Precisely.
Yes, and further down at 616,
Yeah.
16 as
it
well.
Would, if I may respectfully say so,
Yes.
most regrettable in a context such as this,
Yes.
were the answer really to depend upon precisely how people describe themselves. This type of case must depend on the reality, not
Actually,
on the
Lord
form.
Panic, I've lost the plot now, because having indicated that you can have third-party support anyway, you don't actually need your sponsorship.
There were two solutions to
So you won twice, is that it?
I would be
if you
happy
win
to
on
win
both,
once.
yeah.
Win-win situation.
There's nothing else I could possibly
It's a belting
Brexit approach.
Yes.
Well, thank you very much. Mr. Fordham, I think it might be convenient if we adjourned and saw you at 2 o'clock for your address in AM2. But for the time being, we're very grateful to Council for their assistance in the first batch of cases. Thank you very much.
Because I'm going to say